This hearing starts like a routine bond reduction request, but within minutes, the courtroom turns into a tense battle over money, family, and some extremely serious allegations. A 19-year-old defendant stands accused of continuous sexual abuse of a minor, and now the judge has to decide one critical question. Should his bond stay sky high at $150,000, or should it be lowered so he can get out of jail while awaiting trial? But here's where things get complicated. His own mother is in court explaining that she may have to sell her home just to try to help him, while also raising 3 younger children under the same roof. And prosecutors are not buying the argument that the family can't afford the current bond. In fact, the state is about to argue something that completely changes the tone of this hearing. They claim the issue isn't inability to pay, it's priorities. Watch closely, because this case becomes a legal tug-of-war between public safety, constitutional bond rights, and a mother trying to hold her family together under impossible pressure. And trust me, when the judge finally delivers the ruling, neither side walks away fully satisfied.
As far as if he were to make bond, regardless of the amount, you said that he was not going to be residing with you.
No, because I have my daughter.
And how old is your daughter?
I have my 16-year-old and my 12-year-old.
Okay. So you have 2 children under the age of 17.
I have 3. My youngest, my son is 11.
You have 11, 12, and 16. Did I understand correctly? And they would be residing with you. I'll pass the research.
Any further questions?
No.
All right, the court is calling CM number 097847, State of Texas versus John Anthony Ayala. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Alex Scharf for the defense.
And are you John Ayala?
Yes.
All right, we're here. The the defense has filed a motion seeking a bond reduction. State, have you had a chance to review the state defense's motion, and are you ready?
Yes, Your Honor, we are.
All right, defense is your motion.
Thank you, Judge. Call Yvette Ayala as a witness.
All right, Ms. Ayala. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand if you state your name for the record.
Yvette Ayala.
All right, defense.
Thank you, Your Honor. Ms. Ayala, where do you live?
151 Bancroft.
In San Antonio?
Yes,
All right. And are you working?
yes, sir.
Okay. Where do you work?
Commercial kitchen parts and service.
Okay. You married?
No.
Okay. And John is your son, is that correct?
Yes,
How old is he?
19.
18. Has no criminal record, is that correct?
No, sir.
Now, you know that he's charged with a continuous sexual abuse for minors, is that correct?
Yes.
Right here, you can already see the defense trying to build the emotional and financial foundation for a bond reduction. The strategy is very deliberate. They're not arguing that the allegations are minor, because they absolutely are not. Instead, they're focusing on something courts often consider during bond hearings: the defendant's ability to actually pay the amount set. The mother explains she may need to sell her house just to come up with enough money, and even then she's balancing the needs of 3 younger children. That matters because bond is not supposed to function purely as punishment before trial. Legally, it's intended to ensure the defendant returns to court while also protecting the community. But here's the problem for the defense. Prosecutors are likely thinking, if she can eventually come up with the money, then maybe the bond is doing exactly what it's supposed to do. This is where bond hearings become incredibly subjective. One judge may see hardship, another may see potential access to funds. And viewers, think about this carefully. Should a family's financial sacrifice influence whether someone accused of a serious crime gets released?
And that the bond is currently set at $150,000. Is that correct?
That's what I heard.
Okay. Now, do you have $15,000 to pay to a bondsman or to someone to get him out on that high of a bond?
No, sir.
All right. Is there anything, property that you own or that you can, is there an amount that you can get together of money that you could put towards a bond to help to get John out of jail?
I'm currently trying to sell my house.
Okay.
With the money that I get back, though, I'm trying to make sure I get my other kids set up. And 'cause I don't have any more vacation time to take, so when I have doctor's appointments and stuff for here, I have to take an unpaid day off, so. But crunching the numbers and everything, I mean, I can do like 5,000.
All right. And in the event that the bond is reduced or or you're ever able to make it, where will John be living?
With my grandmother.
Okay. Are there any minors under 17 that live there?
No. Not that I know.
Is that your mom?
No, it's my grandma. My mom's another option as well.
Okay. There are places where he can.
This exchange about where the defendant would live if released is more important than a lot of people realize. The court isn't just worried about whether someone can post bond. They're also looking at risk factors tied to the allegations themselves. Since this case involves accusations involving a minor, the judge and prosecutors immediately zero in on whether any children would be around him if he were released. Notice how carefully the questioning is framed. The mother repeatedly clarifies that he would stay somewhere without minors present. That's not accidental. The defense knows housing conditions can make or break a bond reduction request. But then the prosecution starts digging deeper into finances, and honestly, this is where the hearing gets uncomfortable. The state is essentially challenging whether the family truly lacks the ability to pay or whether they simply don't want to redirect money away from housing stability and other obligations. And from a human perspective, that's brutal. This mother is talking about selling her home, protecting her younger kids, and trying to help her son all at the same time. No matter what side you're on, you can feel the emotional weight building in this courtroom.
Live that
Yes,
would not violate any conditions.
yes.
Okay. Pass the witness.
Just a few questions. Ms. Ayala, you said you owned your own home?
Oh, I'm still paying for it, yes.
You have a mortgage on your home? Okay. And the $5,000 that you said that you could come up with, is that are you taking into consideration other things, or is that just based on the sale of your home?
That's based on the sale of the home, and after I pay off what I need to make sure my other children are stable, I need a place for them to live.
If you were going to sell your home, where are you going to live?
Our plan right now is to sell our home, get an apartment. I would like to pay it for a year because, like I said, with my hours not meeting, I don't want to stress over eviction.
So the 5,000 you're considering is in part due to you want to prepay your rent. As far as if he were to make bond, regardless of the amount, you said that he was not going to be residing with you.
No, because I have my daughter.
And how old is your daughter?
I have my 16-year-old and my 12-year-old.
Okay, so you have two children under the age of 17.
I have 3. My youngest, my son is 11.
You have 11, 12, and 16. Did I understand correctly? And they would be residing with you. I'll pass the list.
Any further questions?
Nothing further, Judge.
All right,
Pass
call
the
the
witness.
Call your next witness.
We rest.
All right, Steve.
Yes, Your Honor. At this time, say we just offer safety exhibit number 1, which has been previously tendered to defense.
No objection.
All right, then states exhibit number 1 is admitted into evidence. Just give me a moment to read it. All right, the court will hear argument. Defense, it's your motion.
Thank you, Judge. After reading the exhibit that the state tendered to you, I believe that most of the allegations happened or alleged to have happened when Mr. Ayala was a juvenile. To take that into consideration, that might have an effect on the jurisdiction of the case. 18 years old, no priors. Has a safe place to stay. Understand the seriousness of the charge.
The defense attorney just made a comparison that always sparks debate in hearings like this, arguing that even some murder cases receive lower bonds than this one. Now, legally, comparisons like that can be persuasive emotionally, but they don't always move the needle with judges. Why? Because bond isn't determined by a simple ranking system of this crime versus that crime. Courts also consider the specific facts alleged, community safety concerns, victim protection, prior history, and whether the defendant poses a risk if released. The defense is also leaning heavily on the fact that many of the alleged acts reportedly happened while the defendant himself was a juvenile. That's a calculated move aimed at softening the court's perception of him. But prosecutors immediately push back by reminding the judge that juveniles can still face extremely serious consequences for violent or sexual offenses. And then comes the key issue, the alleged age gap between the defendant and the alleged victim. That detail alone can dramatically influence how a judge views danger to the community. At this point, you can feel both sides trying to shape the narrative before the ruling lands.
But $150,000 bond, I mean, I've seen murder cases with less than that. Stabbing, shootings, all that kind of stuff. I would ask that you reduce the bond from $150,000 to $50,000.
All right, state.
Yes, Your Honor. I guess two things from the state's perspective. Number one is just the offense in and of itself, which the court is well aware of, and the seriousness of these allegations, and the defendant's own admission to committing these offenses. The court's well aware that juveniles go to prison as well for these types of offenses. So the fact that he was a juvenile doesn't negate the age difference in this case, which I believe is, if I'm calculating it correctly, would be at least a 9-year difference between the two individuals. Secondly, in determining what is the appropriate amount to set in this case, obviously the courts can take into consideration the ability for the defendant to make bond. And so in this case, I don't believe that Ms. Ayala has demonstrated through, or the defense through Ms. Ayala has demonstrated the inability to pay, rather the inconvenience of being able to pay. She has other understandable uses and needs for that money, but prepaying a whole year of your rent, even assuming rent is $1,000 a month, that's $12,000 right there. And that's including, talking about her having to have at least 3 kids, and that would be pretty relatively safe to expect that'd be $12,000 right there. And so it's not the most convenient way for her to use her money, but obviously I don't think that should be taken into play with what the court is going to consider. And so we're asking that the bond, the writ be denied, that the bond is.
The prosecution's argument here is sharp and honestly pretty strategic. Instead of saying the mother is lying about finances, the state reframes the issue entirely. They argue this is not about impossibility, it's about inconvenience and financial choices. That distinction is huge in court. Prosecutors are basically telling the judge, yes, the family has financial pressures, but they still appear capable of accessing money if they truly prioritize making bond. And notice how they specifically mention prepaid rent and future housing plans. That wasn't random. They're attempting to show the court that substantial funds may become available through the home sale, weakening the defense's argument that the current bond is unattainable. Meanwhile, the defense counters by emphasizing uncertainty. The house hasn't sold yet, the money doesn't exist yet, and the defendant has already been sitting in jail for over a month. This becomes a classic courtroom balancing act between constitutional rights and public protection. And viewers, here's the real question. Should bond decisions focus more on the severity of allegations or the realistic financial ability of the accused and their family?
Already appropriately set at an amount based on the nature of the offense, the specific allegations of this offense, and the lack of evidence to show that the defendant has the inability to make the bond as presently set.
Defense, it's your motion, so you have final argument.
Thank you, Judge. Ms. Ayala, told the court she doesn't have the money. She's in the process of selling her house. God knows when that will happen. Or how much it'll be. But clearly she doesn't have the money to make this bond right now. She's justified to that under oath. When and if the house gets sold, depending on what it gets sold for and all that. Her son is still in jail. And he's been there for over a month, and it's his first offense, and he's been throwing up all morning. Let's get out. And we think that realistic just bond can be formulated. I believe full house arrest has already been ordered as a condition of his bond, where you can lower the bond to $50,000 and protect and give protection to the community, to the alleged victim. And so we're gonna say that we did show that she cannot make the bond right now at this moment.
All right, so this is what the court is going to do. The court is going to set the bond at $130,000, full GPS waive fees, no contact with minors.
In the end, the judge lands somewhere directly in the middle. The defense wanted the bond reduced from $150,000 to $50,000. Prosecutors wanted it unchanged. Instead, the court lowers it slightly to $130,000 while imposing strict conditions, including full GPS monitoring and no contact orders. That tells you exactly how the judge viewed this case. The court acknowledged at least some concern about the financial arguments presented by the defense, but clearly still viewed the allegations as serious enough to justify a very high bond and heavy supervision conditions. This hearing also highlights something people often misunderstand about bond court. These proceedings are not trials. The judge is not deciding guilt or innocence here. The court is weighing risk, safety, financial ability, and the likelihood that the defendant returns to court. And emotionally, this hearing showed the ripple effect serious criminal accusations can have on entire families, especially when younger children and housing stability are involved. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you, Judge.
All right, are we ready on Stephanie Gomez? Stephanie Gomez?